Well, good morning. Welcome to the ISS Immigration Law Forum. We are very delighted that you're able to join us today. I am Rudy Altamirano. I'm the Director of the International Student and Scholar Services and the Director of Immigration and Integration Services here at the University of Pennsylvania. We are very excited to have two of our esteemed lawyers from one of our top-notch law firms in Northeast area in the United States. I would like to, before I start, I would like to take this opportunity to introduce both of them. I'll start with Jane Goldblum. Jane Goldblum is a founder and partner of Goldblum and Pollins, a certified women's business enterprise. With more than 30 years of experience in immigration law, Jane represents some of our nation's finest universities, medical centers, research institutions, corporations, and private employers. Jane is consistently listed as one of the best immigration attorneys in the United States, as one of the best immigration attorneys in Pennsylvania, and as one of the best business immigration attorneys internationally. She is frequent author and speaker on employment-based immigration options at national and local conferences of the American Immigration Lawyers Association, or AILA. She previously served as editor-in-chief of AILA's authoritative text, the David Stanton Manual on Labor Certification, and special recruitment articles. Jane also represented the Commonwealth of Pennsylvania on a trade mission to China, where she spoke on immigration investor and intra-company transfer strategies. Jane has been retained on multiple occasions and as an expert witness in the field of immigration, and is frequently called upon to provide immigration advice to local, state, and national elected officials. Welcome, Jane. Our next colleague is Ron Klasko. Ron Klasko is the managing partner of Klasko Immigration Law Partners, LLP. He has been providing immigration assistance and solutions to universities for over 30 years. Ron is a past national president of the American Immigration Lawyers Association and served for 3 years as the Bar Association's General Counsel. Ron has been selected as one of the 6 top-tier immigration lawyers in the U.S. by Chambers Global. The firm has been selected also as top-tier immigration law firm by U.S. News and World Report, and Ron has been selected for inclusion in Best Lawyers in America for more than 25 years. After repeatedly being selected for inclusion in Law Dragon's Human Resource Executives list of the most powerful employment attorneys guide, he has been inducted into the Hall of Fame in 2018. He is also the only lawyer to be honored twice with AILA's highest honor, the Founders Award, presented to the person or organization who has had the most substantial impact on the field of immigration law or policy. Of course, he is a frequent author, lecturer on business and university-related immigration law topics. He has been providing immigration legal advice to the University of Pennsylvania community for over 3 decades, been served as national chair of AILA's U.S. Department of Labor Liaison Committee and Business Immigration Committee, has testified before the U.S. House of Representatives for a committee on the judiciary and the U.S. Commission on Immigration Reform. It will take hours for me to introduce both colleagues, but I would rather have them talk about their wonderful achievements and the knowledge that they have to talk to you about it. So here is what will happen. Mr. Klasko and Ms. Goldblum will talk about and present on the developments in the area of immigration, and then I will be asking them questions and answers. The questions that I will be asking are based on the feedback that you have provided when you sign up for this session. We will not be monitoring the chat because we're expecting about 1,000 participants, so it will be unfair for us to not monitor the chat and not able to accommodate you. So what we did was compiled your questions and put them into certain themes. The immigration session will also be recorded that you can review at the end of the session. Without further ado, I will give it to you, Ron and Jane. But before that, I would like to acknowledge the presence of our colleagues from ISS who did a phenomenal job behind the scenes. Lily Zhang, who's the Senior Associate Director. Ryan Villanueva, who's the Assistant Director for Community Engagement and Integration. Niall Miller, who is our Marketing and Outreach Coordinator. And Jackie Bilek, who is our Global Student Outreach Specialist. Ron and Jane, we are so honored. Take it away from here. So now, if you don't mind posting the presentation, and then Ron and Jane will drive the presentation. And we'll end up with Q&A at the end. Ron, you're muted. There you go.
Okay. Good morning, everybody in the Penn time zone, and good afternoon or good evening to the Penn community around the world. Rudy, thank you very much for inviting Jane and me to present on this very important and very timely subject. And my congratulations to the entire ISSS team for so timely putting together this program. On the first slide, which is entitled New Developments, what I've tried to do is put together a number of different things that are happening at the same time that make this one of the most challenging times ever to navigate the U.S. immigration system. The next slide shows 5 different things that are happening concurrently that together create the difficulties that people are having, and that Jane and I are going to try our best to clarify for everybody. So at the same time, we have the following things happening. U.S. consulates around the world have been closed for a few months already and will be closed indefinitely. And that obviously is making it difficult or impossible for people to apply for visas to the U.S. We do not know exactly when consuls will be reopening. We do know that at most consuls, all appointments before August have been canceled, and we don't know if things will proceed in August. At the same time as that's happening, the USCIS, the Immigration Service, has announced plans to furlough up to 80% of its employees beginning in August for financial reasons. We don't know for sure if that's going to happen, but it has been consistently threatened, and it may mean that the USCIS will virtually shut down or largely shut down beginning in August. We also have in April, President Trump issued a presidential proclamation to bar people from getting green cards overseas, what's called immigrant visas, for 2 months. And then a couple of months later, on June 22nd, he issued another proclamation that did 2 things. Number one is it extended the immigrant visa ban, which had been 2 months, through the end of 2020. And secondly, and the focus of our conversation today, is he created a brand new non-immigrant or temporary visa ban that is effective at least through the end of 2020. Now, while all this is going on, we also have a variety of countries for which the U.S. has travel bans or quarantines where you have to be out of that country or that area for at least 14 days. And this includes places such as China and the EU and Brazil and others. And we also have situations where where parts of the world have bans on people coming from the U.S., where they are either banned or will be quarantined for a period of time. So when you put all of these things together, we're in a period of arguably unprecedented challenges and a time where it's really critical that you check in with your trusted advisors at ISSS or with your immigration lawyer before you take any action whatsoever, and certainly including traveling. So with that said, Jane's going to pick up and talk about this new non-immigrant visa ban just issued by President Trump on June 22nd.
If you can unmute, Jane, if you can unmute. Yeah, that would be great. Thank you.
Okay. Can you hear me now?
Yes.
Terrific. Hi, everyone. I want to thank Rudy and the ISS office and Ron for permitting me to try to unravel these horrific bans that basically we've been dealing with almost since the January travel ban of the Chinese, followed by the Iranian ban of the Iranians, which Ron alluded to. But we're going to focus on what the June 22nd ban means to you. Let's go to the next slide. What is this proclamation? Let's focus on the words suspends entry, because that's really important. It suspends entry of aliens who present a risk to the U.S. labor market following the coronavirus outbreak. What is the purpose of the proclamation? It's a travel ban. While the coronavirus is spreading in this country and to address the high unemployment of U.S. workers. It extends, as Ron said, the April 22nd proclamation banning entry into the U.S. for immigrants, and then it creates that new ban for non-immigrants. What is its message? If you are outside the U.S. without an immigrant visa or a travel document, or the specified non-immigrant visas, H-1B, L-1, and certain J-1 visas, whether or not the consulate opens, you will not be able to obtain a visa and enter the U.S. through at least December 31, 2020, and longer if this proclamation gets extended. Its other message is a bit comforting to you, and goodness knows we're looking for comforting news, and that is if you're in the U.S., if you are here with a valid I-94 authorizing work in HLJ status, you're okay. This proclamation doesn't impact you so long as you don't travel. The next slide, please. So who is affected? And you're going to hear this over and over again because it's important. H-1Bs, H-2Bs, L-1s, and certain J-1s who are outside the U.S. And the J-1s who are affected are your student interns and other interns, trainees, teachers, your camp counselors. You're seeing the resorts are empty of foreign nationals because those J-1 workers have also been banned. Ron's going to tell you who is not affected, the good news.
Thank you, Jane. So who is not affected? The people not affected, number one, F1 students are not affected. Number two, other J1s other than the ones that Jane mentioned are not subject to the ban. So J1 students, J1 scholars, J1 professors, J1 doctors are not subject to the ban. If you're in the US as of June 22, you are not subject to the ban. There is presently some controversy, and you have to be very careful. If you're in the US as of June 22, you're fine. If you have a valid visa, you can still use it. If you're going to need to leave the US and get another visa, right now there is some question that is being raised of your ability to do so. And I want to emphasize that this is brand new. There's no formal interpretations yet from the State Department or the Immigration Service. And even though we as lawyers may read it a certain way, there's no certainty that the government will. So as of right now, we are advising our people who are in the US as of June 22 that they can remain here, that if they have a valid visa, they should be able to use it. But we are not yet prepared to suggest to people that they can leave the US and get a new visa. If you are in possession of a valid non-immigrant visa, you are not subject to the ban if you're in possession of that visa as of June 22. One thing we don't know. So for example, if you have a valid H-1B visa and it's still good, you are not subject to the ban. However, what if you have, for example, a valid B1, B2 visa, which is also a valid non-immigrant visa? Does that mean you're not subject to the ban and you can get an H-1B visa? We think the answer is yes, but it's not at all clear that the government agrees or has taken a formal position on that yet. Technically, the presidential proclamation says that if you have a valid travel document, you're not subject to the ban. Well, a passport is a valid travel document, but we don't think they're going to interpret it that way. And we think that what they mean by that is a valid USCIS document, such as a re-entry permit or advance parole. So the bottom line is if you're in the US as of June 22, or if you have a valid non-immigrant visa, you shouldn't be subject to the ban. There is a national interest exception, brand new, no history of interpretation. We expect we will be attempting to use this, but again, we don't have any precedents. It relates to two major things. Number one is if you're coming to the US to do something related to medical treatment of this pandemic of COVID-19, that may be in the national interest, or if you're doing something involving coming to the US that's going to help improve the US economy, that may be subject to this national interest exception. Lastly, Canadians are not affected by the non-immigrant visa ban because Canadians do not need visas to come to the US, and this has to do with entering the US with a visa. At first, we were not sure if the government agreed with that interpretation. Over the last 2 or 3 days, we've gotten confirmation that the government does apparently agree that Canadians are not subject to this non-immigrant visa ban. All right, so Jane, that's some of what we know. There's also lots that we don't know, right?
Oh. Excellent, great. What we don't know, actually this list could get a lot longer. But what don't we know? What counts as a travel document? Actually, we kind of know that it really is a visa for green card holders who might have been overseas and lost their green card. It could be a boarding foil, which we know is going to be almost impossible to obtain because why? Consulates are closed. Also advance parole. These are travel documents. But for your purposes, what is needed? An F1 or a J1 visa to enter the US for your purposes. Then we are asked, are H1B1s for Singapore and Chile exempt? Are E3s for Australians? How about TNs for Mexicans? How about OPT-F1s? Are they exempt? The bottom line is we believe that H1B1s, E3s, and TNs for Mexicans are exempt. We don't really know why, because remember when we talked about what the purpose of this ban was? It was to basically address the very high unemployment in the US. So that doesn't really make sense, but believe me, we're celebrating everybody who is not included in this ban. Will USCIS adjudicate petitions for banned individuals? We're getting approvals all the time, as I'm sure Ron's office is. So as of right now, before they run out of money and furlough their staff, petitions are being approved, being submitted and approved. Will US consuls approve visas now for entry after the ban? up until a few days, I was saying, try to make your appointment. And then I found out on Twitter that the Department of State said, nah, we are not going to be issuing visas for any of those that are outside the US seeking visas who are banned. So that answer will be, as of, I guess now, or as of my authority is Twitter, no.
So
Ron,
let me,
Ron, do you have anything to add about that?
no, other than, hopefully we haven't reached the point where Twitter is official policy of the government, but that is certainly an important indication of where at least
Right.
some in the government stand on that position right now.
I think it's fascinating that they're on Twitter offering guidance.
So let me, Jane, let me take it from there and talk about on the next slide what we call the new realities and the future challenges. And if we go to the next slide, I want to talk to you about the main advice we are giving to people right now. Number one, and most important, we are advising all of our clients who are in the US to avoid traveling outside of the US until further notice. Any travel at this point is potentially risky, whether it has to do with the country you're going into and whether you'll be able to get into it, or various travel bans, or this non-immigrant visa ban, or possibly future proclamations from this president as we get closer to the election. Travel is precarious right now. Speak with your advisor at ISSS or your immigration lawyer before traveling. Now, what we are doing for our clients is looking at creative ways to deal with these bans. So there are a number of our H-1B clients. There are, for example, H-1B medical residents that we may now have apply for J-1s for. So anybody who was likely to be an H-1B, we're looking for alternatives. And the alternatives may be a J-1, it may be a TN-1, which Jane has mentioned for Canada or Mexico, and which is not subject to the ban. It may be an O-1. An O-1 visa is for someone of extraordinary ability. Certainly it's true that some of our H-1B may qualify as O-1s. We wouldn't normally do it because it's more complicated, but still it may be that they qualify. So anybody who would have normally been an H-1B who's now subject to the ban, we're looking at some of these options. And the slide also mentions something called B-1 in lieu of H-1B. And basically what that means is if you have an overseas employer, and the overseas employer is going to continue to pay you while you're in the US, and you're going to be doing a job that is of an H-1B level in the US. Under certain circumstances, you may be able to come here with a B-1 visa, which is not subject to the ban, and be admitted for up to 6 months with that visa. So the bottom line on all of these things is there's a very limited group of people who are subject to the ban. And for example, most of the people on this call are not concerned about L1s, which are subject for the ban, but if we have people who might normally be L1s, a lot of them may qualify for E2s, and E2s are not subject to the ban. So again, your immigration lawyer will be able to consult with you to talk about what options are available to you if the normal options are no longer available. So Jane, before we get to Q&A, maybe you want to talk about other things that have been mentioned within these presidential proclamations that are almost a preview of coming attractions, other things that we think may be coming down the road in addition to what we've talked about.
Okay. The big question is, what is the future of OPT and STEM specifically STEM OPT. But let me backtrack a little bit. If you read section 5 of the proclamation, the June 22nd proclamation, basically what President Trump does is it says to the Department of Labor to consult with the Department of Homeland Security and come out with new regulations or new programs to basically make sure that US workers are not quote unquote disadvantaged. Now, if you consider that was the language also in the April 22nd proclamation, we should be happy because they could have, or they could have, and they could have included OPT in this proclamation and didn't. So that is actually good news. However, we're aware of Chad Wolf, who's the acting secretary of the Department of Homeland Security, who basically stated, we're doing something, so stay tuned. The rumors abound that they plan to do something maybe in mid-July, and I've also heard August. But when I was thinking about and reading about what is going on in the O1 world, one, we know that nothing has happened yet, and that's cause for some celebration, some relief. And we also know that there have been two fronts trying to affect OPT, particularly STEM OPT. One has been a court case that's been around for, I guess, 4 years, brought by the Washington Alliance of Technology Workers. Now, this is really interesting. They had a court hearing at the end of 2019, because remember, this lawsuit is against the Department of Homeland Security, and the representative of the department said, wait a second, we don't want you to have an injunction. Why? Because we say that STEM workers do not adversely affect, do not do irreparable injury to US workers. I thought that was hugely fascinating. So the bottom line is that we are hearing from the DHS that there is an irreparable injury. So why do we need to impact or change the OPT reg? Now, there are two ways, and this is what you're trying to figure out. How will this be done? Basically, they can actually implement what's called an interim final rule. But everybody knows that if they do that and they somehow change OPT, and we don't even know, they provided no details how they intend to do that, that people, universities and others are ready to go to court immediately to challenge it. The other way that they can change OPT is through regulation, which frankly takes time. And that is, I think, the more probable way, because Trump hasn't been that successful in court recently. Yay. But if nothing happens, what should you people who hold OPT know? And I've been saying this for a few years and doing this for a few years, as Ron's office has. I've been saying to the OPT holders, wait a second. If you have OPT and you have hard to find skills, and sadly you're from any country other than India or China, you can pursue a perm-based green card case and literally be at a point where you can apply for permanent residence within 12 months. We have 3 cases right now where they have been able to bypass the H-1B by doing that. So yes, you're hearing, on one hand, you're hearing, oh my goodness, they may change OPT. On the other hand, you're hearing, if you have OPT, 12 months may be enough with hard to find skills. Certainly 36 months is enough. Think about pursuing a green card with your employer without delay. How will the H-1B requirements change? Well, again, I'm trying to basically talk about you all know or should know about the new registration, which actually made it a lot less costly. And for those who hold advanced degrees, more likely for you to capture an H-1B, because under the new H-1 process, 65,000 of the 85,000 visas will go to the advanced degree. So how have the H-1B requirements changed? Think March 1st. Your employer should merely register electronically. At that point, there's no filing, there's nothing to establish eligibility. It's merely registering. And the registration period last year was, I think, March 1st to March 20th. And then there's that random lottery. So basically, that part is, I guess, good, except we still have a lottery. The second part is what I just talked about with respect to Section 5 of the proclamation, where supposedly the Department of Labor is supposed to promulgate other regulations to protect the disadvantaged U.S. worker. So, we're not sure what that will be, but that could be a stay tuned. And then finally, Ronald, this is a big slide. Will H-4 employment authorization survive? That also is kind of similar to the OPT situation. We have a court case and we have the DHS threatening to promulgate the elimination, really, of H-4. And interestingly, in that court case where there was a hearing I think that was recently, the DHS, also the defendant in the case, said, we don't see H-4s taking away computer-related jobs either. So that's just a very important fact. And I'll just add one more fact, which I think is really important. We all have heard of the unprecedented amount of unemployment in the US, whether it's 30 million workers or 40 million, I'm not sure. But what's interesting is during this same period of time, the unemployment in the computer sector actually dropped to under 3%. And the other part that I'm going to add, which is a little comforting, because goodness knows Ron and I have been searching for good news to share with you, the number of green card perm-based filings actually went up 16%. You would have thought there would have been a freeze. And the amount of audits, we think largely due to lack of funding, went down. So yeah, there are all these future challenges. We could speak about each one of them for an hour and a half, but I hope this gives you some idea about the challenges and, yes, uncertainties that abound. Ron, do you have anything to add to that?
No, just very briefly before we get to Q&A. You may be a little bit more optimistic than I am. I think that we will probably see most likely in August, a regulation to eliminate H-4 employment authorization. I think we will see regulatory changes on H-1Bs that will make H-1Bs much more difficult to get. Things they're talking about include only taking H-1Bs who make the highest salaries, imposing very substantial fees on employers who apply for H-1Bs, the numbers being thrown around start at $20,000. And I agree with you, Jane, that they may well try to do this without the normal, what's called notice and comment period. They may well try to make these changes and more with regulations that are final upon being issued. And I totally agree with you that these will be challenged in court if they try to short circuit the process. So with that said, I think Jane and I have completed our prepared remarks. And Rudy, we're happy to deal with any questions.
Thanks, Ron and Jane. These questions are coming from the registration of the students. When they registered for the session, we asked the prospective participants to submit questions. There's a lot of questions here. A lot of them were covered in your presentation, but for some of those who were late, I'll try to see if I can ask questions based on that. I said that we will not be able to accommodate all those in the chat because of time limitation, but if there's time, I might change my mind. I might go back to the chat and ask some questions there based on time limitation. So we divided the questions based on thematic patterns here. We have some patterns here. The first one is with regard to the overall proclamation for suspension entry, and I will ask questions about J, H, and F1J1, and also other visa statuses. Okay. The first question is for Ron, and this is J1 related. Based on your presentation and based on what we read on the proclamation, is it safe to assume that the J1 categories of the proclamation will not affect university-wide J1s?
Yes, well, it is safe to assume that the proclamation will not affect J1 students, J1 research scholars, J1 professors, J1 doctors.
Okay.
Now, when I say that, I tell you that as a lawyer, that is 100% clear to me, which means that if you're a J1 research scholar, you should be able to obtain a J1 visa. Now, this is brand new, and we have consular officers who may or may not be as clear on everything as they should be. They may or may not have gotten training on this. And anytime there's something new, and you have new consular officers, they may be inclined to say, well, geez, I'm not sure I can do this. And even though it's very clear that, for example, a J1 research scholar should be able to get a J1 visa, there may be delays if the people at the consulate are not as sure of what the law says as we are. So Rudy, I think this is an area where it should be clear and hopefully will be.
Okay, thank you, Ron. I know this is not impacting J1 research scholars, but we have a lot of research scholars, I think, who is joining us today. Will this affect the J1 research scholars' ability to travel, even though they're not covered by the proclamation?
Rudy, it should not. If you are not covered by the proclamation, and a J1 research scholar is not, this proclamation should not affect your ability to travel and get another visa. That doesn't change the overall advice I give, which is pretty much for everybody right now. Unless it's a necessity to travel, we prefer you don't. There's uncertainties at consuls when they're going to open up. When consuls open up, there may be a 3 or 4 month backlog because they've been closed for 3 or 4 more months. Again, we talked about country-specific travel bans, both for Americans going to them and for people from those countries going here. So, and we're also getting closer to an election. And President Trump does view, and is very clear, immigration restrictions as something that may be helpful to him as things get closer to the election. So it is not impossible that there'll be further restrictions. So yes, a J1 research scholar should be able to travel and come back, but the I've given of check with your ISSS advisor or your immigration lawyer before you travel kind of overrides all other advice.
Okay, thank you, Ron. Let's go to H-1Bs, a very general question for Jane. I know that it might impact the ability of H-1B employees to enter the US, especially if they're doing consular processing. However, does the proclamation prevent current H-1B employees here at Penn from traveling abroad? I know you said don't travel, but if they have visas already, H-1 visas, they need to attend a conference. Of course, this can be impacted by the COVID-19. Are you discouraging those H-1B employees at Penn from traveling abroad, even though they have H-1B visas?
That is a really hard question.
Mm-hmm.
And forgive me for saying this vis-a-vis any of the Chinese nationals who would be hearing, but I'm being very protective because of, frankly, the Chinese proclamation. And just the fact that you have a visa does not necessarily guarantee entry. The message to all holders is probably to consult with your advisor, maybe consult with an attorney. I think we all hope and believe if you have a visa, there shouldn't be a problem. If you're a Chinese national who's in a research capacity, I really would encourage you to get an opinion from the international office as well as an attorney before traveling.
Thank you, Jane. Let's talk about scope, Ron. This is for Ron. I know you alluded to this earlier. Will the proclamation affect Canadian H-1B employees generally and of course specifically?
The short answer is no, it should not. This started as something that I had as an open question because in my opinion, it doesn't, because it talks about people who are entering the US based on visas that are banned. And since Canadian nationals do not need visas, we felt they should not be subject to the ban. We have since then found out that at least some high-level officials at US Customs and Border Protection have stated that they agree that Canadians are not subject to this ban. So as of right now, that seems to be the official position.
Thank you. What is going to happen with H-1B petitions that were filed as consular processing for students who are currently inside of the United States? And can you change from consular processing to change of status after its approval?
So the answer is yes, you can. Even though you originally set up the process for having the approval notice sent outside of the US and you were planning on getting your visa outside of the US, it is possible, not always bureaucratically simple, but possible to change your status in the US, even though you indicated you weren't planning on doing that. Now, in order to do that, you have to show that you have a valid, unexpired status in the US to change from. I can tell you that in every case possible, we will be trying to get our clients to change their status in the US in order to avoid being subject to the ban. And certainly if it's somebody who's going to need to get a new H-1B visa outside of the US, I would very much hesitate to have a client go out, even if they seem to be not subject to the ban because they're in the US, until there's clarification of how the US consuls are going to interpret this. I'd much prefer to have every client apply for change of status in the US and not leave the country and apply for a visa.
Thank you, Ron. Jane, back to you as an F1 question here. How does the proclamation impact students who plan to switch from STEM OPT to H-1B?
Well, right now, the proclamation doesn't bar them from doing that. And of course, we are, as Ron said, we're encouraging everyone to stay in the US, which is basically via change of status. But to be eligible for an H-1B, there are basically 5 tests that I would ask you to think about. One is, are you eligible for a change of status? And this is really a commercial, how important it is to foreign students and J-1s never to work without authorization, because you are only permitted to change your status if you have never violated your F or J status. The other one is if you don't have a job offer with a university or hospital or a CAP exempt institution, you need to remember, think March 1st, you're going to participate in the lottery. So be mindful of that.
Thank you. Is it safe for students? I'm sorry, Jane, continue.
No, I mean, I just want to quickly go through all the points because this is important for those that are on STEM OPT planning to get that H-1B. They also have to be aware of whether the offered position is a specialty occupation, basically is utilizing the courses that they took at Penn. And then also be aware, as Ron and I have been discussing, of future changes that basically were part of this proclamation, Section 5, saying we want more. So be aware if there are changes. And then finally, if you're on STEM OPT, goodness knows, think green card. Think the perm-based green card process. That's it.
Thank you. Jane, I have one more for you. How does the proclamation affect current cap-gap students?
Well, really doesn't. If they have secured an H-1B valid till that is supposed to start in October 1st, they're good. They can continue to work. This is one of the ways OPT has been extended if you have an approved H-1B.
Okay. Ron, I don't know whether you covered this in the presentation, but I think it will be beneficial to share something about this. Does the new proclamation affect those in TN, O1, E3? I know the answer to our permanent residency pending status.
Again, short answer, no, but I'll give a little bit of an explanation. So as you look at this, it's important to understand that if it is not in the ban, if it's not an L1 or an H2B or certain categories of J1 or an H1B, if it's none of those, it is not subject to the ban. So if you're a Canadian or a Mexican who might normally be an H1B, TN1 is fine. If you are someone with extraordinary ability who would normally be an H1B, we can definitely look at doing an O1 application. If you're from Australia and you would be in the type of person who we would normally do an H1B for, we may be able to do an E3 for you. The E2 visa category for people who are starting businesses in the US and who are a national of a treaty country, we can do that for you. If you're applying for permanent residence in the US, this does not affect you. And the bottom line is that what this presidential proclamation does is only affects people who are applying to get into the US with a visa and trying to get a visa to be able to enter the US. If you're in the US already, this does not affect you unless you're going to be leaving the US. So if you're changing status from one visa category to another in the US, it doesn't affect you. If you're applying for a green card through what's called adjustment of status in the US, this does not affect you. So that doesn't mean that nothing that's going to happen will affect you. The authority that the president has to issue these proclamations only is based on his authority to decide who can come into the US. In order to try to place restrictions on people already in the US, he would have to do it differently, and he would have to do it by regulation. And we've talked about the fact that we do expect that there will be regulations issued to try to place limits on people in visa categories that allow them to work in the US, but under something called the Administrative Procedure Act. In order to do that, they have to provide the public with a time period to provide comments and suggestions regarding that. And unless they try to waive that or to get around that, it will take quite a while for all that to happen. The big concern we have is that there are indications that they will try to do this without this notice and comment period on the basis of some sort of national emergency or otherwise. We are already preparing our arguments to go to federal court if that happens. I might mention also that this non-immigrant visa ban will be the subject of federal court litigation shortly. There are likely to be several different lawsuits that will challenge various aspects of this non-immigrant visa ban. If anybody listening is interested in being a plaintiff in the lawsuit, they could certainly contact me.
Thank you, Ron. We will move from the proclamation to COVID-related, if you don't mind. And let's start with a travel question here. And I will ask Jane this question. Can students with approved EADs who are unable to return to the U.S. work remotely and maintain their OPT status?
Let me make sure I understand that. Will
Those
F1,
with,
F1 students with an EAD, can they?
Yes, who are not able to return to the United States, can they work remotely and maintain their OPT from abroad? But they have an approved EAD already in their possession.
Yes, there has been some clarification along that line that basically says that if the school has modified their plan with SEVP to say that remote work, remote learning is authorized and it's being monitored, that they can go back and they can go to their home country to work. The issue that we underscore with our F1s, because remember, those who hold OPT are still F1 students. And every time they seek to enter the US, they are subject to what we call 212B, which is, do you have a 100% intent to return to your country? So therefore, applying for a visa, a new F1 visa when you're on OPT has a lot of risk to it. Because the foreign national would have to be able to show, yes, I want to go back to the US to do XYZ, to work in OPT status, but then I absolutely intend to return, and that's often hard to do.
Thank you, Jane. We're moving from travel to grace period, and I have two questions for you, Jane, and then one question for Ron. The first question for you, Jane, is should students who cannot return home during the 60-day grace period following OPT change from F1 to B2 status? Do you recommend?
Yeah, absolutely. As a matter of fact, there has been guidance that to suggest that those who have to be in status in order to change to a new status may need to file multiple I-539 change of status to B2s. I mean, that's a little puzzling to those of us who are keenly aware of the rule relating to B2s. You have to show an intent to return, but it seems clear that those impacted by COVID-19 need to do change status to B2 in order to stay in status.
So talking about grace period, Jane, do you think there's any chances that grace period may be extended for this particular COVID-related special circumstances? Will the government think about extending grace period?
No, I mean, I would welcome Ron's response, but I basically feel that there's no hope for extending OPT to do anything that will help. I mean, think of it this way. We have people outside the US who had diversity lottery interviews, gave the consul their passports, the consul closed, and we have immigration saying, you're out of luck. If you can't come in by September 30th, you totally have lost your ability to get a green card pursuant to the diversity lottery. And when you consider how egregious that is, don't expect a lifeline for extensions, but change of status to B2, do it.
Thank you, Jane. Ron, this is an H-1B grace period question, and J1. Has the government provided any possibilities for extension beyond the statutory limits, i.e. 5 years for J1 research scholars or 6 years of H-1B time, especially for those people who are stuck in the United States and are not able to return home due to the travel restrictions or flight availability?
No, the government has not agreed to do that. We have been in frequent and regular contact with people at the USCIS to try to get them to add some flexibility to the system for people who are completely compliant with the immigration laws, do nothing wrong, and are now being forced to violate their status through no fault of their own because they're unable to travel or otherwise. The USCIS has not been very receptive to any of these things, and it stands in contrast to many other US government agencies that have. For example, the Internal Revenue Service has allowed everybody a 3-month extension to file their tax returns. USCIS has not been doing that, and at least at this point, we're not aware of any plans of USCIS or Congress to do something that would extend the normal time limits for J's or H's.
Okay, thanks, Ron. Let's move to question about visas and embassy operations. One of the most popular questions that we are fielding this past few weeks. When may consulates begin processing non-immigrant visas again? And will there be a backlog for scheduling interviews based on what you know? This is a typical question that we answer in a day-to-day basis, Ron. Maybe they want to hear from an immigration lawyer for this one.
Okay. So when we're talking about issuing non-immigrant visas, of course, there's two types. There's the ones that are banned under the June 22nd proclamation. When will they start issuing those? No sooner than the beginning of 2021. And I say no sooner because there's nothing that prevents the administration from extending this ban further. And of course, we will have a presidential election between now and then that will have a lot to do with that. Now, for visas that are not subject to the ban, when will U.S. consuls start issuing them? All we know right now is that consuls around the world are still closed with certain exceptions for emergency or essential applications. We also know that most of the consuls that we have been dealing with for our clients have postponed all interviews that had been scheduled for July, and the earliest they're being scheduled for is August. Now, originally, they postponed June interviews for July, so that does not mean that everything will be back to normal in August. For whatever reason, the State Department does not seem to be coordinating all of this and announcing an open date, even though almost all of the US operations now are open, even though in most countries around the world, all operations are open. Despite all of that, the US consuls have not announced when they will be opening. So it appears as of this point that the earliest is going to be August, but there's no certainty of that date. Now, let's assume that they do in fact open in August. Does that mean we're back to normal? And the answer clearly is no. If there's been no visas issued for 3 or 4 months, when they open, there's clearly going to be a backlog. And that may vary by consul as to how long it is and to how they're dealing with it. But certainly, we advise our clients that you can't expect that the minute the U.S. consulate in a certain location announces it's open, that everything's back to normal and there's going to be no delays.
Thank you, Ron. Yeah.
Could I add something? I think we all have to step back and say, what is the purpose of these proclamations? It's to address the spread of COVID-19. If we get a vaccine and this country is no longer in a lockdown, I think somehow miraculously consulates are going to be open to permit people to enter the US. I think right now you have to assume, so long as you're reading the news, hearing the news that this virus is spreading in this country, I think we can assume that the consulates are not going to be back, except for emergencies.
Okay.
and if your visa is in the national interest.
Thank you. Now let's go to very general related topic, which is but related to COVID related, and I will divide it between the two of you. The first one is for Ron. Can students who lost their OPT jobs due to COVID-19 be self-employed to stop unemployment from accruing?
So there's a 90-day period where you can't be unemployed on OPT. And if, there are obviously lots of people with the high unemployment now who are facing unemployment. And we have advised them that they can start their own business and be self-employed. We always do say, Rudy, that we view the international offices at the universities as the experts on OPT. And we always suggest that they check with ISSS regarding their position on this. And certainly, I would say this even if you weren't here, that the University of Pennsylvania International Office is renowned around the country for its expertise on these issues. But my position is that, yes, self-employment does avoid unemployment for purposes of OPT in the same way as part-time employment does. Again, I don't know exactly what ISSS's position is, but I believe that employment that even without wages, where that's legal and proper, would also avoid unemployment.
Thank you. Jane, for me, the next question is, what impact, if any, will cashing in the CARES stimulus check have on future green card applications?
Good news, none. A CARES benefit is considered, believe it or not, a tax credit and not a public benefit. So those of us who have gotten those checks, don't worry about the impact. But this is also a way to segue into the fact that if you've ever looked at the new H-1B petition, it asks, have you ever taken public benefits? The green card application now includes 18 pages, I think it's Form I-944, to try to determine if you're likely to take public benefits. But the short answer, if you've gotten a CARES check, cash it, you're okay.
Okay, thank you. Now we'll jump to, we have a lot of people from China here, and I would like to talk about the proclamation for Chinese nationals, if you don't mind. The first question, Jane, stay on the line. How will the current situation on the proclamation for Chinese nationals impact Chinese students getting OPT, STEM extension, and H-1B?
Is that for me?
Yes, that's for you, Jane.
It'll be harder, but not impossible. What will my office do for anyone who is a research scholar or in research somehow in that kind, whether also for a STEM extension, we will be through the training plan for STEM extensions and in the H-1B petition, we will be proving that they are not subject to the proclamation. So there are three ways to do it. They will say that their work in China, whether it was research or other kind of work, did not in any way further the interest of China's military civil fusion strategy. Two, that even their advanced degree, even if it's in one of the quote unquote fields of concern, prepare them to do X, Y, and Z and not to quote further the interest of the military civil fusion strategy. And then three, to show that their proposed employment in the US will be utilizing or having them do X, Y, and Z, which has nothing to do with or is inapplicable to China's military civil fusion strategy. So I think that you can't just bury it and pretend this concern is not there. You need to address it and prove that it's not applicable to your client. And I think it's similar to what all of our clients have faced with the visa mantis and the TAL for years, and that really didn't bar people either. So I would say if you are an advanced degree, not to give up hope at all.
Thank you. Maybe this, Jane, is a very quick answer. Will humanities students be subject to the same scrutiny as STEM students for the Chinese national? Okay, that's an easy answer. I know that will be. Ron, I will ask you two simple questions here. Maybe one of them is not. How long might the suspension be in place for Chinese Nationals proclamation?
The answer is indefinitely. So unlike the immigrant visa ban and non-immigrant visa ban, which are in place until December 31, 2020, unless extended further, the J1, the Chinese ban that we're talking about has no termination date. So it simply says that it's in effect until the order is terminated by the president, which means indefinitely.
And is it safe for Chinese nationals to travel? I think I know
I don't
the
know if
answer
that's
to
an
that.
easy or hard question, but
Yes.
In every case, and I keep emphasizing this, it is mostly not, for a whole lot of reasons, mostly not safe to travel. Certainly for a Chinese person who may possibly, even with a remote chance of being subject to this proclamation relating to the Chinese military civil fusion, even if it's conceivable that they may be considered to be part of that, and even if in the end they would get a visa, it's certainly very possible that there would be a long delay before the US consul determines that they're eligible for the visa. So the short answer I would give is, in most cases, unless you've talked to your immigration attorney, it is not safe to travel in that situation.
Ron, since you're already on the line, I'll just finish with your question here. How will and then Jane will end this topic. How will F2 dependents impacted if their F1 partners are affected by this proclamation?
Yeah, if the F1 principal is subject to this proclamation, it also means that F2 dependents will not be able to get visas.
Yep. Thank you, Ron. And Jane, let's end this with this question. How will students know if their visas have been revoked, and what should they do if this happens?
Well, if they have been, let's take the Chinese proclamations. If it's subject to the Chinese proclamation, if a student has been denied on that basis, they're going to get something called a 212F denial. In our experience, even where there's been what we call administrative processing that everyone's heard about, this 212F is relatively new, you have the ability to rebut. And we expect that if the denials are based on this concern about the military civil fusion strategy, at that point you can present your arguments like it may appear to be, but it absolutely doesn't. And what we have been told, the State Department has indicated that they are going to be turning those cases around quickly, that they aren't going to be lingering like the administrative processing delays. So that's hopeful news. The message is that if there's any chance that you're going to be denied on this basis, be prepared. Have your paperwork ready to submit so there isn't any more delay for you.
Thank you. Now let's go to the general topics. I will 3 questions for Ron, 2 questions for Jane. Ron, how long could it take to get green cards for those who are married to US citizens?
So Rudy, we really haven't talked yet about people married to US citizens. So there are a couple things to know. Number one is people married to US citizens are exempt from the immigrant visa ban. So they can get green cards outside of the US because they're exempt. Number two, if you're married to a US citizen, you're also exempt from the non-immigrant visa ban. So let's say that your spouse is in the US on an H-1B and you want to get an H-4. If you're married to a US citizen, you should be able to get that. Now, The more direct answer to the question is that if you are, let's say you're in the US, you marry a US citizen and you want to apply for a green card. In most cases, you can complete that process in the US through a process called adjustment of status. How long will that take? The question of how long anything will take going forward is a really tough one. In normal times, I would say that in 4 to 5 months, you should be able to get an employment authorization document. And usually within a year or less, you should be able to get a green card. The time period depends on the geographical area where you live in the US and which USCIS office you'll be dealing with. Because of the expected furlough at USCIS, and because of various other layers of delay that have been set in motion within USCIS, I expect that everything will take longer than usual, especially any application that will require a personal interview, and a marriage to a US citizen green card application does require an interview. So going forward, I would say that you should not be surprised if the green card process takes over a year.
Thank you, Ron. What rights do international students have when crossing the border?
The best short answer on that, Rudy, is they have a right to call their lawyer.
Okay.
When you're trying to enter the US, you don't have rights as such. In some cases, if you're denied, you may be eligible to get a hearing with an immigration judge. But the best short answer is if you're having problems at the border, contact your immigration lawyer.
Thank you. And last question for you, Ron. How could remote work affect H-1B approval?
So obviously, a lot of people are working remotely now. And if you normally, if your H-1B has been approved to work at a certain office location, and now you're working at home, that should not be a problem. If you're working remotely in a location far away from where your office is, and if that's going to happen indefinitely, probably you'd want to talk to your lawyer or the lawyer for the company, the immigration lawyer for the company that applied for the H-1B. We do have a client alert on our website, klaskolaw.com, that covers H-1B issues arising out of COVID, and in which we do answer this specific question.
Thank you, Ron. Jane, you ready for your two?
Sure.
First question, when does a student need to get a social security number before beginning work?
Well, think Form I-9. When he or she reports to work, they must present proof of who they are, their identity, and that they have work authorization. A social security card is one of the documents, but it is not the only document. So can you start work without a social security number? Yes, very often the employer will say social security pending. But of course, as soon as they have an approved EAD or an approved H-1B that authorizes them to work, the next step, which is a separate step, is to apply for a social security number that authorizes employment.
And Jane, how can students bridge the gap between the ending of their J1 status and the approval of a change of status to F1?
Well, as we discussed before, if there is a gap, they need to change their status. They need to submit an I-539 for a B1, B2 status. And there really is no other way to bridge that gap.
Okay. Well, before I end this Q&A, I would like to give it back to Ron and Jane. If you have final words that you did not cover in your presentation that you would like to impart to our international students and scholars who are in the call right now, are there any final words or things that you need to share with our constituents?
Well,
Well, I'll be happy to start on that. First of all, again, Rudy, I really applaud you and your staff for putting this together on such short notice after the issuance of the June 22 proclamation. And I think we've really covered a lot of ground. So I guess the only thing I would say is don't assume that because you've listened to or watched this webinar, that you know everything you need to know, through the end of this year. We do expect that there will be more to come. And you really do need to keep up, again, with ISSS or your immigration lawyer, because I think we're going to see more restrictions in the coming months. And we will start to see more clarifications of the position of the government in the coming months. So this is an evolving situation, and hopefully this has been helpful to people in getting a good idea of where things stand now. And if there's any one theme that you've heard throughout, it's really avoid international travel if at all possible.
Thank you, Ron. Jane?
okay. I want to add, again, thank you so much for this opportunity. To all of you out there, if you have questions or concerns, you should feel free to email them. And my office, and I know Ron's office, is very responsive. We understand how much anxiety is out there. And like the Klasko firm, my firm is constantly posting updates on our website, which is thegoldblumfirm.com, and sending out alerts as they become final, when we know something. And as we are obviously, the one area that we are all on the lookout for is what's going to happen with OPT and STEM. I did want to give a shout out to the ACLU that has put together a wonderful list of what to do in the event that you have problems at the border. And I would encourage you all to look at that. But basically, my advice regarding that is be prepared. If you're seeking status as a student who has a 100% intent to return, come with documentation that will support your case. Don't come unprepared. And that goes with every single status. Everything you say and do needs to be verifiable. And that goes to what your current intent is and what your future intent is. So be prepared. But I think the huge message that we are imploring you to take heed is don't travel. If you're here, don't travel without consulting your ISS advisor, and you're fortunate to have the best in the country, or your attorney. And basically, we're here to support you, and good luck.
Thank you again on behalf of the University of Pennsylvania and International Student Scholar Services and all our international students and scholars. We would like to extend our thanks to you, Ron and Jane, for your wonderful partnership through the last 14 years. And it's amazing. These are one of the wonderful law firms in the United States, and we are so fortunate to work with you. I know we have a lot of questions that were posted in the chat. What we'll do, since this is recorded, we will also try to look at your chat questions and make the most out of them in terms of themes, and see if we can answer your questions through our FAQs. And we will share this with our team in ISSS to make sure that we'll be able to look at those individually. You can also follow up with your individual advisors in the International Student and Scholar Services. And of course, Ron and Jane, for any complex cases, will be more than, and you need an immigration lawyer or immigration law firm, we'll be more than glad to provide information with regard to that. We are very, very thankful on behalf of the university and ISS. We are very much aware of the challenges that you're going through during these challenging times. And we will, rest assured, we will continue to work with you, to advocate for you, and make sure that We give you the information that you need. You ask during my tea time fireside conversations a month and a half ago, and one of the requests is for me to be able to bring immigration lawyers, and I think bringing them to this to discuss with you all the information related to your situations and the immigration landscape. We have provided that. Continue to send your recommendations. We'll be doing our best to do that. Again, Ron and Jane, thanks so much. We appreciate all your support and your help. Thank you. You are wonderful folks. Thank you. With that, this is the end of our Immigration Law Firm Forum. We'll see you on campus hopefully soon. Thank you. Appreciate it. Bye-bye.